and that's 1830. Now, we can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore, it's been replaced by statutes. They would be more truthful if they said there isn't any common law anymore, it's been replaced by martial law. How many times have you heard? I've heard it lots of times where somebody will say, well, yeah, there is no common law anymore, it's been replaced by statutes or whatever. You see what I'm saying? I don't know. Have you guys ever heard that before? I've heard it.
The reply on that would be what? I'm sovereign man and the...
Well, there isn't any common law anymore because in the martial law, there is no common law. But you still have access to common law. Remember, martial law is voluntary. Remember, it said you have to volunteer in. They create the zip code. Okay? So if you're in that federal regional area, then you're under martial law. But are you? That's the question, isn't it? Because I'm not. And so then I have access to common law. And the Supreme Court rules even talk about common law. Okay, so you have access to common law. You just have to understand that not to volunteer. You understand how not to volunteer. Okay, into their martial law jurisdiction. Zip codes is one of the ways. Okay, there's actually a bunch of different ways, but you have to understand what's happening and how it's happening, and then just make a conscious choice not to volunteer and change your life a little bit. It's not that difficult. It's just a way of changing your habits. Quit giving out Social Security numbers, okay? Because that's one of the big ways they get you in there, and make sure that they know in uncertain terms that who you are. So again, under martial law, there's no common law, okay? And we'll talk about that more, but. All you have to do is learn how to quit consenting, how to quit volunteering into that martial law jurisdiction. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rules. So, you go into their courts and that's what they want you to do. Follow the rules of civil procedure, right? Well, that's governed by martial law rule. Equity has always been understood to follow the law. When they say equity is also understood to follow the law, we're talking common law. Okay, that's what they're saying. Equity is always understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And that's what you see in the courts nowadays, where you sit there and the judge will say, I can do anything I want. Well, he's right. He doesn't have to follow the common law because he's under martial law, and that gold-fringed flag right there is your evidence. And so he can literally do anything he wants because normally equity follows common law, but when there's no common law, then equity follows its own course, which means he can do anything he wants. Right? And so that's exactly what's going on, and that's why you see the courts doing whatever they want to do. But again, our solution is with our own courts. And we can choose not to participate in that. So that 10 federal regional areas is here, but so is the Republic of Texas. It's 2 jurisdictions right here, right now, depending on what you tell them. That's all it comes down to, is what you tell them. Martial law is really no law at all. It's a dictatorship. What is called proclaiming martial law is no law at all, but merely for the sake of public safety in circumstances of great emergency, setting aside all law and acting under military power, a proceeding which requires to fall by an act of indemnity when the disturbances are at an end. It's been going on for probably since the Civil War. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights or duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, but they are bound by its obligations. So, you see what's happening. What they're essentially saying is that when you give them a Social Security number or a driver's license, okay, those are fictitious entities, then you are saying that cannot be said to be exercising nor be entitled to pure personal privilege. Rather, they assumed the rights and duties of the artificial entity. Okay? When you give that to them, you're saying that I'm assuming this entity right here. That's essentially what you're saying. Okay? That's why you can never give it out. That's the reason I tell them. Okay? I don't have one. And I don't. Texas Administrative Code. Characters of print acceptable in names. Entity names may consist of letters in the Roman alphabet. Only, A, B, only uppercase or capital letters with no distinction as a typeface or font will be recognized. So that's where it's saying, under the Texas Administrative Code, has to be in all block capital letters. That's why the name on the driver's license is all block capital letters. Right there. U.S. Declaration of Independence. He is affected to render the military independent of and superior to the civil power. Gee, that sounds like martial law. He is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. Well, gee, that sounds like martial law, and pretended legislation sounds like color of law. For imposing taxes on us without our consent. Gee, that sounds like martial law. For depriving us in many cases of the benefits of trial by jury. Gee, that sounds like martial law. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government. Gee, that sounds like martial law. Enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. Gee, that sounds like martial law. He has abdicated government here by declaring us out of his protection and waging war against us. Gee, that sounds like martial law. For protecting them by a mock trial. Gee, that sounds like martial law. Causes and necessities for taking up arms. Statutes have been passed for extending the jurisdiction of the courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the custom and inestimable privilege of trial by jury in cases affecting both life and property. Gee, that sounds like martial law. And for altering fundamentally the form of government established by charter. Gee, that sounds like martial law. We saw the misery to which such despotism would reduce us. Gee, that sounds like martial law. Despotism is just another word for dictatorship. A person does not have to consent to canon law. Canon law presumes that the Creator left the Pope everything and he was to be trustee of the Divine's trust. Since no one rebutted the presumption they consent to canon law, happened at the first conclave, I believe in 1302. From that day forward, any time a vessel financed by Rome, all of them, that explored new territory, planted a flag in the name of the church. Since the natives didn't rebut the presumption, everything on that landmass became the property of the Pope. In 1666, King Charles II signed the Sesticate Trust Act. Thus, for the first time, we have a testamentary trust, a trust for the deceased into which the estate of the deceased is conveyed. On the same day this act was signed into law, the town of London burned. Maybe it's under this type of trust that you are now classified. You're a fictional entity. You legally died at the age of 7, and your property was put into an estate, and the government's a trustee. Canon 1170, a divine trust is the highest possible form of trust and unique, only possible type of trust that can hold actual form rather than rights of use of form being property. Canon 1171, in accordance with these canons, a divine trust can never be terminated. That's why they spell the name in all block capital letters on a headstone. In accordance with these canons, every child or higher order spirit that is born from now until the end of time possesses a divine personality through the creation of their divine trust before any other legal entity or claim. That's why they have statutes to say that all persons have to register their births with the government, okay? Again, if you are a person, then you better do what you're told. Trust. An equitable right, title, or interest in property. Remember, we're talking equity again, right? Real or personal, distinct from legal ownership. Beneficial interest. That right a person has in a contract, right? So it's a person, a beneficiary. This term is frequently used and synonymous with the technical phrase Sesticate Trust, remember? And that's all tied in with the Vatican and this King Charles I that, right here, Charles II, signed the Sesticate Trust Act in 1666. A beneficiary, a person. A settler is a person. A founder is a person. That's why I don't have anything to do with trusts. Okay? Now that's not to say that I don't manage a trust, but I'm not anything other than that to do with any trust. So I'm not a beneficiary, I'm not a trustor, I'm not a, you see what I'm saying? A founder, a person who founds or establishes a trust, again, it's all persons. And the key is not to be anything to do with the trust. Grantor is a person. These are all different law dictionaries, and they all say that a beneficiary is a person. There's 3 definitions there, and they're all persons. And this is Black's 8. The settler is a person, a founder is a person. A creator is a settler, which is a person, a donor. A settler, again, a donor, the second definition of a donor is a settler, which is a person. Equity, and this is talking about equity again. Equity is in the early history of law, the sense affixed of this word was exceedingly vague and uncertain. This is owing in part to the fact that the chancellors in those days were either statesmen or ecclesiastics, perhaps not very scrupulous in the exercise of power. It was then asserted that equity was bound by no uncertain terms or rules, and that it was alone controlled by conscience and natural justice. Okay, that's taken from Blackstone's commentaries. Anyways, well, we'll go on and then we'll talk about it. A court of equity is one which administers justice where there are no legal rights, but courts of law do not afford a complete remedy. Now, when they talk about courts of law, we're talking common law. And where the complainant also has an equitable right. Okay, now mortgage, the bank has an equitable interest in your property. Okay, that's all they have. Equity, the system of law or body of principles originating in the English Court of Chancery, superseding the common law and statute law, together called law in the narrow sense. Okay, so they're saying common law and statute law are law in the narrow sense. When the two conflict in appealing to the equity of the court, she's appealing to the king's conscience. In other words, when you appeal to equity, you're asking them to do the right thing. Say, for example, at common law, if you go through a stop sign and run into somebody and kill them, right? Then either A, you have to, the guy's married, okay, either A, and has kids, either A, you have to pay to support the wife for the rest of her life and pay to support the kids until the age of majority, or B, they take you out back and stone you, okay? That's at common law, that's the way it is, okay? There's no jails at common law. And that's why jails are a privilege, okay? And that's why if you waive the benefit, then you won't get to go to jail. Anyways, so equity, you could make the argument at equity saying, look, it was an accident, I stopped, and I didn't see him, or who knows what. You see what I'm saying? And so you're asking the court to do the right thing and bend the rules a little bit, and they have that power. That's equity, okay? Now, at common law, they have to follow common law when common law is there. But when there's no common law there, then they can do anything they want. When there's martial law, they can do anything they want, literally. And but otherwise, they have to follow common law. Everything they do is under probate law. It's for dead things. A person is a dead thing. Are you a dead thing? Whereas taxation, whereas taxation by the Parliament for the purpose of raising a revenue has been found by experience to create great uneasiness and disorders, that from and after the passing of this Act, the King and Parliament of Great Britain and all will not impose any duty, tax, assessment, whatever payable in any of His Majesty's colonies, provinces, or plantations in North America, except such duties that may be expedient to impose for the regulation of commerce. Okay, in other words, they cannot impose taxes except for the regulation of commerce. And that was in 1778. Notice that's 2 years after the Declaration of Independence. And probably the War of Independence still going on. So, anyways. Every nation on the planet is under martial law. Every nation on the planet is bankrupt. I will show unto thee the great judgment of the great whore that